Drake is demanding to see Kendrick Lamar's agreement with Universal, and Universal is saying, I don't think so. They gave us a copy of the discovery itself. I'm so excited to go through this. I would just be objecting all over the place with this. Ooh. All right, so what we do is, in the lawsuit by Drake against Universal for Kendrick Lamar's Not Like Us song, I kind of love being a litigation attorney because I get to get all the secret sauce documents from the court. Now we have a little bit of a special treat today. We don't normally get to see what I'm gonna show you, okay? But because whatever is filed in the case, whatever is part of the court's docket, I, as a lawyer, can go and get it. If you're following this case as closely as I am, don't forget to subscribe. I'm gonna continue giving you a lawyer's reaction to all the things happening in this case, so subscribe. Let's go, let's go. All right, so where we're at today is there's been a motion to dismiss filed, so meaning the response from Universal to Drake, because remember, Drake is suing the record label Universal, not Kendrick Lamar, okay? And so Universal has now responded saying essentially this: Your Honor, these were diss tracks. As diss tracks, no one's gonna take them seriously. It's extreme exaggeration, and oh yeah, by the way, Drake participated in this just as much as Kendrick. Drake was just as defamatory as Kendrick. And Universal's attorney even threw out there Drake has previously signed petitions saying that lyrics should not be taken literally in the creative expression of making music. So essentially, Universal's main argument here is that the court should just kick out the complaint altogether because these were diss tracks and no one's taking them seriously. So, you know, this isn't defamation, allegedly. So then what's been filed following that motion to dismiss is what we're talking about today. And here's where I'm gonna start. This letter was drafted by Universal to the judge. Dear Judge, we represent Universal in the above lawsuit. Pursuant to the court's order, we are writing you this letter. We are asking stay of discovery. Okay, so what they're saying is we want you to put a temporary pause on discovery. As soon as someone files a lawsuit, in most jurisdictions, you can serve discovery, which are like questions, right? You can serve requests for documents. You can ask the other side to answer questions, admit certain things. And so Drake's legal counsel has already served discovery on Universal, and Universal is saying, well, we just filed a motion to dismiss. If we win on this and we get the entire complaint kicked out, we don't want to waste our clients' time and money to answer your discovery. Now, as an exhibit to this letter, they gave us a copy of the discovery itself. I'm so excited to go through this. All right, so pursuant to the court's rule, we got together with Drake's attorney, okay, and we said, hey, will you agree to this stay of discovery? So we're just gonna hold tight. Will you agree to it? And then let's see. We participated in a 20-minute call. It's so funny. These they're called meet and confers, and so pursuant to most, courts and rules, but certainly in federal court, the court's like, hey, before you bring me your problem, you guys have to go and try to sort it out. So you're required to have a little phone call to get together. So that's why they're saying there's like, we met at 1 p.m. and we talked for 20 minutes. All right, so they go on to say, we had our little call, it didn't work out, and Drake's attorney said, I will not agree to hold on discovery. I want to keep going. As outlined in the motion to dismiss, all of Drake's claims fail as a matter of law. His defamation claim fails because when assessed in the context of the Not Like Us song, it conveys non-actionable opinion, rhetorical hyperbole, right? So extreme exaggeration, not fact, an issue for the court to resolve as a matter of law, right? So just again, Your Honor, it's not defamation. And I think it's a really interesting argument. And I said this in the last video that I did covering this. I feel like the attorney does have a good sense of creative, diss track, rap culture. And then in the letter, the attorney for Universal goes on to compare to another case. So he goes, look, in regards to this case, Barstool Sports Incorporated, where the federal court concluded as a matter of law, and the Second Circuit affirmed, that alleged defamatory statements, quote, laden with epithets, vulgarities, hyperbole, and non-literal language and imagery made in the context of a public and very acrimonious dispute, including several statements made in a diss tract in which defendants rapped, quote, a constant stream of insults and slurs about plaintiff were non-actionable. So they're saying, Your Honor, look at this other case. Pursuant to this other case, other courts have found that even if they say mean things, even if it is highly offensive and all this good stuff, it doesn't matter because it is opinion, it's non-actionable. Okay, so that's what they're saying in this letter. So basically Universal is just recapping what it put in its motion to dismiss. So it goes on, Universal makes a strong showing that Drake's claims are meritless, right? There's no basis, and at a minimum that the motion to dismiss is not unfounded in the law. And then, this is kind of the point I made about First Amendment freedom of speech. Critically, courts in this district have emphasized that defamation defendants must be protected from unnecessary discovery to safeguard First Amendment protections. So here's what happens, guys. With discovery, you get so much access, you get so much information because you're really allowed to go kind of fishing, right? If it's related to your claims, you can ask for documents, admissions, you can ask them to, answer questions, you can do depositions, and you're allowed to ask anything under the sun or get anything under the sun that could be relevant or could lead to something relevant to help you prove your case. But pursuant to what Universal is saying, they're like, but this is a defamation case, and we have First Amendment rights that need to be considered here. So they don't get to just go on a fishing expedition. And what they're asking for, again, this is all in context. We're going to look at what what Drake's attorneys are actually asking for. So a discovery stay is particularly warranted here, given the untenability of Drake's defamation claim and the First Amendment rights at issue. All right, so look, let's take a peek. What is the discovery? All right, so this is Exhibit A to the letter, and they have served what are called requests for production. Remember I was saying there's 3 types of discovery. We do requests for production, so we want actual documents. We do requests for admission, so we send and we say, admit you signed the contract on January 1, 2025, right? And then there's also interrogatories. Interrogatories are where you just ask questions, okay? But this is a request for production. So they're starting with, we want documents. What do they want? So first request for production. They want all contracts between you, right? So you being Universal, as well as any person, entity acting on behalf of, all right, so basically Universal. Between Universal, Kendrick Lamar, so you want Kendrick's deal? You want to get the contract with Universal, huh? His agents, anyone working on his behalf? Ooh. All right, so what we do is if I got this and I'm representing Universal, because here's the thing, I know that there's confidentiality language in these contracts, and if someone is trying to get a contract that is subject to confidential terms, I'm gonna clap back and I'm gonna say, no, you're about to cause a breach of contract because I'm not allowed to share this with you. But anyway, so we want copies of contracts between Universal and Kendrick Lamar, as well as if Universal has any agreements with, let's say, his manager, his agents, right, vendors, merchants, and any agreements reflecting your right to approve, reject, refuse to publish, edit, alter, veto the publication of Kendrick Lamar's musical works, music videos, or other content. Now, here's the thing. I mean, look, I don't want to get too technical on this, but I would beat this question up because it's asking more than one thing. It's asking for all contracts, but related to different things, different people. But nonetheless, they want contracts so that they can prove that there are certain third parties that have vetoed, amended, edited, or published any of Kendrick Lamar's music. So what, are you trying to find other people to sue? Or are you trying to show that Universal has had problems with maybe publishing some of Kendrick Lamar's stuff previously? Number 2, all documents, communications, right? So all documents, emails, text messages relating to your approval or consent to publish the recording, image, and video. Okay, so this is going to be the Not Like Us song, cover art, the actual video. Okay, yes, I think they fairly so are entitled to that. All communications involving Ramon Alvarez Smirkle relating to the recording, image, and video or promotion of the musical works by Kendrick Lamar. Number 4, they want to know about marketing funds that were spent. Okay, this goes to their claims. This goes to their claims that they juiced. They want to know, did you juice the numbers? Any documents and communications regarding any payola violations related to the musical works by Kendrick Lamar. Okay. Anything related to the copyright restrictions for the song, the video, policies, procedures, guidelines. This part, I know what they're doing here. They want Universal's policies, procedures, guidelines related to the enforcement of copyright restrictions over publications, playing, streaming, sharing. Because, you know, a bit of what they're saying is they go, there was unequal treatment of Drake as, you know, an artist signed with Universal. Universal has been favoring Kendrick Lamar, and they had a negotiation that they had to, you know, coming up, right, to renegotiate Kendrick's deal. And one of the things that Drake claimed is that there's been not only preferential treatment, but that Universal has been violating its own policies in what it's done related to the Not Like Us song. All right, all documents, communications related to the February 2, 2025 Grammy Awards. Oh, this is interesting. Relating to the song, the video, including but not limited to all documents, communications with the National Academy of Recording. See, I would just be objecting all over the place with this. How is this relevant? How does this have anything to do with the defamation unless you're just trying to say that by extension and in the ongoing promotion and just trying to defame Drake through the Grammys, you're looking for anything to try to support these claims. All right, looks like same thing. Super Bowl halftime. Here we go. Document request number 9. They want all documents, all communications with the selection and licensing of this song to be performed at the halftime show. All documents and communications sufficient to show the number of streams, views, downloads, purchases, radio plays of the song, of the video. Yeah, so do you see why Universal's like, look, before you get to go peeking, and you don't get all this stuff, right? They're going to object very heavily to a bunch of these requests, but they're saying, Judge, they want all this stuff, and if we are able to get the complaint kicked out, they're not entitled to see any of this. Oh, we saw claims about this. Number 11, they want documents to show the compensation structure. There's all kinds of allegations thrown around in regards to Interscope Chief Executive Officer John Janik for the past 5 years. They want copies of litigation notices. I mean, they're burning through, guys. Just so you know, you only get so many, right? So it looks like they've exhausted almost all of the requests for documents right out the gate. Okay, this one goes to Drake's damages. All documents and communications related to the armed attack and the trespassing attempts at Drake's Toronto residence, right? So if you remember, he opened the complaint by basically being like, you know, imagine waking up in the middle of the night and someone is opening gunfire, and he said one of his security guys got hit. I mean, very traumatic and very dramatic in creating a narrative around the damage, the harm that he alleges that he has suffered because of Universal's defamation. Documents sufficient to show the total money spent by Universal directly or indirectly on the production of the recording and video. Here's the other thing. I would really beat this up because there's not really adequate definitions used in this. Documents sufficient to show the total monthly money spent by Universal directly or indirectly on the promotion of the Not Like Us song and video. So we don't get to usually see the actual discovery. We don't file this with the court. And the only time we'll file discovery with the court is when there's some kind of problem, like someone is refusing to answer questions, and so we have to get the court involved. So at this stage, Universal is trying to get the court involved to say, we don't want to answer, please put a stay into place. So are we shocked by what we're seeing here? The answer is no, and the reason is because they're on this path now, right? Drake has filed this lawsuit, made all of these allegations, and so now he has to prove it. And he has to prove it by going and getting all of this information, the evidence, right? And like I told you, this was just the request for production. This is only the documents. So we haven't seen interrogatories yet. We haven't seen requests for admissions yet. But you guys tell me, of the requests that we went through, which ones do you think are the most outrageous, or do you think these are all perfectly fine? Don't forget to subscribe. I'm going to continue covering this. I'm Top Music Attorney, and I'll see you on the next one.